Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
All right, welcome back to the Deep Dive. Today we're going to be tackling a topic that, unfortunately, I think affects a lot of people out there. We're talking about workplace harassment and discrimination.
Absolutely, yeah.
And to help make sense of it all, we've rounded up some, I guess you could call them landmark legal cases. Ones that have really helped define what constitutes illegal behavior at work.
Yeah, exactly. Because, the law, it can be a bit of a maze to navigate. But these cases offer these like real world examples, examples that help us see the principles in action. So think of this as like a cheat sheet to understanding the basics.
Yeah. So we're not going to get bogged down in the complexities of the law today.
Okay,
right? We're going to really just try to cut to the chase, keep it straightforward and understandable.
That's the goal. We want you to walk away with a clear grasp of these concepts, so that you can identify and understand, what's acceptable in the workplace and what crosses the line.
Exactly. So we'll be focusing on three specific cases today. The first one is Harris v. Forklift Systems, Inc. The second one is Oncale v. Sundowner Offshore Services. And then finally, we'll be looking at Vance v. Ball State University.
Three really important cases that have had a really big impact on how we view harassment and discrimination in the workplace today.
Yeah, and hopefully by the end of this deep dive, you'll have a much better understanding of this entire topic. So, okay, let's start off with our first case. Harris v. Forklift Systems, Inc.
Okay, so Harris, this case was decided by the Supreme Court in 1993, and it actually ended up setting a really crucial precedent for how we define a hostile work environment. The case revolved around Teresa Harris, who decided to sue her employer, Forklift Systems, because she was alleging that her boss, the company president, was creating a hostile work environment for her, specifically because of her gender.
Yeah, and from what I understand, this president's behavior was pretty egregious, right? Like we're talking repeated insults, demeaning comments, really targeted and offensive stuff.
Yeah. Absolutely. And so the question that really came up for the court was whether you have to show actual psychological harm, like a diagnosable injury, to be able to make a claim about an abusive work environment.
Yeah. Like, do you have to actually be like clinically depressed or something because of what's happening at work for it to count?
Right. And the Sixth Circuit Court of Appeals, they initially sided with the company.
Really?
They said, yeah. Essentially, they said that in order for Harris to win her case, she needed to prove that the harassment directly caused her to suffer some kind of psychological injury.
So basically, they were saying, toughen up, buttercup.
Kind of, yeah. It's a pretty high bar to clear, right?
It does seem like they were setting a pretty high bar. You can imagine being in a situation where like you're facing constant harassment. It's making you miserable, but maybe you haven't reached a point of like a full-blown breakdown,
Exactly. And that's where the Supreme Court comes in. They actually reversed that decision. The reasoning was really key here. So they pointed to Title VII of the Civil Rights Act of 1964,
right,
which basically prevents discrimination based on sex in the workplace. And they said, this act comes into play before somebody has a nervous breakdown.
Oh, okay. Interesting.
Like you don't have to wait until it gets to that point.
Right.
So you don't have to be completely debilitated by it in order for it to be illegal.
So they were saying you don't have to wait till things get super extreme to recognize that something's wrong.
Right. That's exactly it.
That makes sense.
Yeah. The court really emphasized that the point of this law is to prevent discrimination.
Yeah.
It's about creating fair workplaces, not about waiting till somebody is completely broken down and then stepping in.
Gotcha. That's kind of like saying, it's better to prevent a fire than to wait until the whole house burns down before you call the fire department, right?
Perfect analogy, yeah.
So where's the line, though? Like, how do we distinguish between something that's just like, I don't know, a little annoying or offensive versus something that's actually creating a hostile or abusive environment in a legal sense?
Yeah, that's a great question. And the court recognized that a single instance, like just one off-color joke or one offensive comment, that alone probably wouldn't violate Title VII, But it's when those comments or behaviors become a pattern, when they're sustained, repeated, and there's specifically targeting you, based on your gender, your race, or whatever it might be, then it crosses that line. It's the difference between one offhand remark and a consistent pattern of targeted harassment.
So it's kind of about the cumulative effect, right?
Yeah.
Like the more it happens, the more pervasive it is, the more likely it is to be considered illegal harassment.
Exactly. And the court was really specific about this. They said that it needs to be judged from the perspective of a reasonable person.
Okay, yeah.
So it's not just about how the victim feels. It's about whether a reasonable person in that situation would find it hostile or abusive as well.
So you're saying both perspectives matter.
Absolutely. It has to be both.
Gotcha. So, I mean, this Harris case, it really did has a huge impact on how we understand these types of claims going forward.
Right. Absolutely.
It shifted the focus away from just the victim's mental state.
Right.
And it made it more about looking at the work environment itself. Like, is this a place where any reasonable person would feel harassed or discriminated against?
Exactly. So for our listeners out there, this is so important to remember. You don't have to have a mental breakdown. You don't have to reach that point of crisis for harassment to be illegal.
Right.
And if you're experiencing it, addressing it early on before it escalates is always the best course of action.
Okay, so that was Harris v. Forklift Systems, a real game changer in terms of understanding hostile work environments. Now, let's move on to our second case, Oncale v. Sundowner Offshore Services.
Okay, so Oncale. This case really digs into a different but equally critical question about workplace harassment. It was decided in 1998, and, it dealt with this issue. Whether Title VII, which is the law we talked about earlier, whether that law's protection against discrimination also extends to same-sex harassment.
Oh, interesting.
Yeah. So Joseph Oncale, he was the plaintiff in this case. He worked for Sundowner Offshore Services, and he claimed he was being sexually harassed by some of his male coworkers.
Okay, so, I mean, to me, it seems kind of obvious that harassment is harassment regardless of the genders of the people involved, right? But I guess back then, it wasn't so clear-cut.
You're right. You'd think it'd be straightforward, but back then it wasn't. The lower courts actually ruled against Oncale.
Wow, really?
Yeah, they said that Title VII just didn't apply in situations of same-sex harassment.
Oh, wow. So back then, they basically said it was okay for men to harass other men because it wasn't covered under the law.
Essentially, yeah. And that doesn't seem right, does it?
Yeah, it seems like that's just, inherently discriminatory.
And the Supreme Court thought so, too. They overturned the lower court's decision. They said very clearly that Title VII does apply to situations of same-sex harassment.
That's good, yeah.
And they were really clear about their reasoning. They said the key factor to consider isn't about who is doing the harassing and who's being harassed in terms of their genders. It's about whether someone is being treated differently, worse because of their sex.
Oh, that's interesting. So it's not about the genders of the people involved. It's about whether the behavior is creating a discriminatory environment based on sex.
Exactly. Like, for example, if you have a group of men who are constantly bullying another man, and they treat women in the workplace totally differently, that could be considered same-sex harassment.
Oh, okay.
It's because they're treating him differently because he's a man.
Gotcha. So it's really about the impact of the behavior, not just the intent. Like, if you're creating a hostile environment for someone because of their sex, it doesn't matter if you're attracted to them or not. Right.
Right. And the court made a really important point here. They said, even though the law is about sex discrimination, the harassing behavior doesn't actually have to be motivated by sexual desire.
Oh, that's a good distinction.
Yeah. And they even went on to give examples of what would count as same-sex harassment that could be actionable under the law.
Oh, like what? What kind of examples?
Well, they mentioned things like, repeatedly asking for sexual favors or pressuring someone for sex, that kind of thing. But they also talked about situations where, someone's being harassed because the harasser just generally has a problem with people of the same sex being in the workplace at all. Like they have a deep-seated bias.
Oh, just...
Yeah. And they also mentioned, looking at how the alleged harasser treats people of different genders in the workplace. So if they're treating people of one gender worse than another, that can be evidence of discrimination.
So let me see if I get this. Let's say there's a guy at work who's always putting down and undermining his male colleagues, but he treats women completely differently. Could that be seen as same-sex harassment, like rooted in this idea that he doesn't think men should be in that kind of role or environment?
That's a really good example, yeah. That's exactly the kind of situation the court was talking about.
Okay, wow. It's amazing how much nuance there is in this whole area of the law. And this Oncale case, it was a landmark case, right? It really helped clarify that harassment is about the impact it has on the victim, not about who the harasser is or what their motivations might be.
Yeah, absolutely. It really broadened our understanding of harassment. It's not just about unwanted sexual advances. It can take many forms.
Okay, great. So we've covered two huge cases now, both of which have had a major impact on how we view harassment in the workplace. Now let's move on to our third and final case for today, Vance v. Ball State University. And this one delves into the really specific question of who exactly qualifies as a supervisor in harassment cases, which have, big implications for when an employer can be held responsible.
Yeah, for sure. Vance, this one was decided in 2013. It's centered around Maida Vance, an African-American woman who worked in catering at Ball State University. And she said she was facing racial harassment from a white coworker named Sandra Davis.
Right.
And the big legal issue here, the issue that made it all the way to the Supreme Court, was whether Davis, this coworker, should actually be legally considered Vance's supervisor.
Okay, so I'm curious, why was this distinction between a supervisor and just a coworker so important?
Well, because under the law, employers have a higher level of responsibility when the harassment is coming from a supervisor.
Oh, okay.
They can be held more directly accountable.
I see.
It's called vicarious liability. Basically, it means the employer is liable for the supervisor's actions because the supervisor is acting on behalf of the employer.
So the legal standards for holding an employer accountable are different depending on whether the harasser was a supervisor or just a coworker.
Exactly. And in Vance's case, the Seventh Circuit Court of Appeals, they said, nope, Davis wasn't a supervisor.
Oh, okay.
And the Supreme Court, when they looked at the case, they agreed. They actually ended up using this case to set a very specific, narrower definition of what a supervisor actually means in these kinds of cases.
And what was their reasoning for narrowing that definition? It seems like that was a key part of their decision.
Right. They were really concerned with clarity. They wanted to make it really clear who fit into that category. So, according to the Supreme Court, a supervisor is someone who has the power to take concrete actions that affect your job. Like they can hire you, fire you, promote you, demote you, give you a raise, change your job duties significantly, or even affect your benefits.
So it's not just about being a boss in like a general sense. It's specifically about having the authority to make big, impactful decisions about someone's employment.
That's exactly it.
Okay.
The Supreme Court actually rejected a broader definition that would have included people who just, direct your daily tasks, Like if someone can tell you what to do every day, but they don't have that power to hire or fire, the Supreme Court said, well, that doesn't make them a supervisor for the purposes of harassment law.
Oh, okay. So they really drew a bright line there, huh?
Yeah, they were all about clarity. And their reasoning was that by having a very specific definition, it makes it easier for judges to make decisions about whether an employer can be held responsible. It takes some of the ambiguity out of it.
Yeah, I can see how that would make things a bit more straightforward from a legal perspective. But, does it raise any concerns? Like, what about situations where someone might not have the official power to hire or fire, but they still have a lot of influence, Like, what if they can make your life at work miserable, even if they can't technically fire you?
That's a really important point. And, a lot of legal experts and employee advocates have pointed this out. By narrowing the definition of supervisor, it could potentially become harder to hold employers accountable in certain situations.
Oh, interesting.
Right, because if the person harassing you isn't officially your supervisor, you generally have to prove that the employer was somehow negligent in addressing the harassment. Like you have to show they knew about it and didn't do enough to stop it.
So this Vance case, it's a reminder that it's really important to understand who has authority over you in your workplace, right?
Right.
And to be aware of how the formal structure of your company can affect your options if you're facing harassment or discrimination.
Exactly. Because even though employers still have an overall responsibility to maintain a workplace that's free from harassment, no matter who's doing the harassing, the legal standard for proving they're directly responsible, it gets tougher when the harasser isn't considered a supervisor.
Okay. So let's take a moment to sort of recap what we've learned from these three pretty groundbreaking cases.
Sure.
So from Harris v. Forklift Systems, we learned that harassment doesn't have to cause some kind of severe psychological breakdown to be considered illegal. Right? It's enough for a reasonable person to see the behavior as hostile or abusive, and of course, the person experiencing it has to feel that way too.
Right. It's about the environment itself, not just the victim's internal state.
Then in On Call v. Sundowner Offshore Services, that case really cemented the idea that same-sex harassment is just as illegal as any other kind of harassment, right?
Well, absolutely.
It's not about who's attracted to whom. It's about whether someone is being treated differently because of their sex, regardless of the harasser's gender.
That's a key takeaway.
And then finally, in Vance v. Ball State University, we learned about the specific legal definition of a supervisor and how that definition is really important in determining whether an employer can be held directly responsible for the harassment.
And the court really focused on that authority to make tangible employment decisions like hiring or firing.
Exactly. So taken together, these three cases really provide this framework for understanding workplace harassment and discrimination.
They offer some really critical legal guidance, but as we all know, the world is constantly changing,
Right.
And our understanding of what constitutes a truly respectful and equitable workplace is evolving too.
Absolutely. And that brings us to this, I think, really important closing thought.
Yeah.
Creating workplaces where everyone feels safe, respected, and valued, that's an ongoing process, right?
Yeah.
It's not just about checking boxes and meeting minimum legal requirements. So, let's think beyond these specific cases. What role can each of us play in building better workplace cultures?
Yeah, that's the real question.
How can we go beyond just compliance and really actively create environments where everyone feels like they belong, like they're safe, and like their contributions are valued? What can we do individually and what can we do collectively to make that happen?
Big questions to think about.
Yeah, it's something worth considering for sure. So thanks for joining us on the Deep Dive today. And until next time, keep those conversations going.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you'd like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.